Hello, everybody out there in YouTube land. Here today, talking about making a murder again. Talking about Brendan Dassey, the order issued by Magistrate William Duffin to have him released. It's not going to happen today. Probably might. They say if it's going to happen more towards the middle of the week. Just so you know. It's good news though. It's great news. And I'm going to go ahead and go over this document that released the order to release him. I'm gonna go over some parts of it that are interesting, and kind of cut through it a bit. It is a bit kind of hard to understand in certain places. I can understand that. So, anyways, we're gonna move into the first document here, which. Basically the court, Judge Duffin is basically stating, look, this is what's happened. So he basically starts out with the court ordered, that Brendan Dassey would be released in 90 days or he would be retried. That was and those were the stipulations. He was either going to be retried or he was going to be released. Those were the two options when he overturned the conviction. Okay, so he's basically stating that was the judgment he issued. All right. Then he goes on to say, but I did allow for the state, if they appealed this court's decision, I put a stay of judgment in if the state chose to appeal this court's decision. So by doing that, he puts a stay on his judgment, and that essentially means that while the state appeals, the case is still sticking in his jurisdiction, in Judge Duffin's jurisdiction, essentially. So that whatever happens at the appeals court, it has to come back to him, essentially. So, and then what he's saying is that he's that stay is issued for a reason to basically kind of ease the burden of the state, so that the state could choose to go ahead and go out and pursue their appeal without having to try and retry him immediately. That they'll have time to retry him after the appeal. That's what the state granted the state. It gave them the ability to do both things separately. However, by not retrying him immediately, it basically comes down to that it was either a retrial or a release. So he's basically just confirming his original order of release or retrial. So that's where we're going to go here, this first part of the document, and then I'll come back and we'll talk a little bit about the next document and what he says about the case. So the court gave the state 90 days to decide whether it would retry Dassey. If it did not initiate proceedings to retry him, the court ordered Dassey released. The court's order also stated that in the event that the respondent files a timely notice of appeal, the judgment will be stayed pending that appeal. The purpose of such a stay was to avoid the obvious inefficiency of forcing the state to retry Dassey while concurrently appealing this court's decision. We do not think it prudent to require the state to begin a retrial before the Supreme Court's resolution of the certiorari petition. Okay, so that's basically him, kind of stating what judgments he's already made, what's been happening, and kind of some of the implications of some of his rulings were, in regards to the stay, if the state were to appeal his judgment. Anyway, so we're going to move into the next document now, where the respondent files, it says, and then essentially Judge Duffin then puts in there that Dassey contends that his release is appropriate because it's very likely that the state is not gonna be successful in their appeal. Now Judge Duffin writes that in as Dassey's statement, as Brendan's statement. But you gotta imagine, for him to put in what the defense said right there as part of, as a reaffirming of the fact that he knows that the state's case is weak. He's basically saying that he's not saying it himself, but he's saying that the defense contends, or Brendan says, that it's likely you won't, be successful in your appeal. I just think it's a sly way of where he's basically kind of saying, get the message, guy. This is just this dog won't hunt, But I don't know. That's my opinion, and maybe I'm wrong, but it sure seems that way. Especially after I originally read Judge Duffin's original judgment and stuff like that. Yeah, he seems that way. He seems like he has a bit of a kind of a dry sense of humor, and it kind of comes through, I think, in some of these documents, in my opinion. But anyways, so we'll move on to this document here. It also mentions the fact that Brennan has already laid out a plan, where he's going to go, and how the setup is going to be when he's released, and that they worked with a clinical social worker. So we're going to go ahead and move into that document right now. All right, so here we see the respondent appealed, triggering the stay. On September 14, 2015, Dassey filed a motion for release while the respondent appeals this court decision. Dassey contends that release is appropriate because it is unlikely that the Court of Appeals will reverse this court's decision. He does not pose a risk or danger to the community, and he is not a flight risk. He proposes a detailed release plan prepared with the assistance of a clinical social worker. I also want to point out here, it just seems funny to me that Judge Duffin is putting in what Dassey contends like that, saying that the state's appeal is likely to fail. I don't know. It just occurs to me that may be his own clever way of telling the state that, but portraying it as the defense contends that you're not likely to win your appeal. I don't know. I just saw that as a little bit funny. It's not him saying it, but he did decide to put it in there, and I just thought that was funny. All right, so in this next document, we're going to see where Magistrate Duffin basically tells, the respondent, state of Wisconsin, exactly what he thinks of the merits of the case. He basically says that he believes that the previous district court or whatever, that they improperly applied federal law by saying that Brendan Dassey had not been, no promises of leniency or anything like that were made. He thinks that that's completely wrong. He believes that they totally misapplied the law to come to that decision. And then he moves on to talk about the actual confession itself, where he says that court should have never, ever, ever found that confession voluntary. It should have never happened. So he clearly has some strong feelings regarding the case, obviously, but he obviously feels that the promises were made. And if you've been watching my videos, you know that very clearly there's one audio clip that I play where you can't deny it is a full rock solid promise, okay, that he will not be going to jail. So he just needs to forget about that because it ain't gonna happen. That is what is said to him. So yeah, I agree with Judge Duffin. Judge Duffin knows what he's talking about. So we'll go ahead and move into that document right now. I'll show you that, and then we'll come back and we'll talk. Independent of the Court of Appeals' unreasonable factual finding that the investigators did not make Dassey any promises of leniency, this court also found that the Court of Appeals' decision that Dassey's statement was voluntary was an unreasonable application of clearly established federal law. The Court of Appeals' decision reflected a consideration of certain facts in isolation rather than under the totality of the circumstances, as the Supreme Court has made clear is required. Moreover, the Court of Appeals failed to consider the highly significant fact that not only was an allied adult not present with Dassey during the interrogation, but the investigators deliberately exploited the absence of such an adult. Given the false assurances of leniency that the investigators made repeatedly throughout the interrogation, when considered alongside Dassey's young age, significant intellectual deficits, lack of any unrelated experiences with law enforcement, as well as other factors, Dassey's confession was clearly involuntary. The Court of Appeals decision in this was very unreasonable. Okay, so now I'm just going to go over a few things, some things said by in the document by Judge Duffin, by Magistrate Duffin. One of them is when he's talking about the reason why Brendan should qualify for release. He mentions one thing. He says Brendan's prison record shows him to be exceedingly benign. Exceedingly. I mean, that's pretty interesting word to use. That basically means that Brendan isn't causing any trouble or doing anything in there that's in any way, noticeable. Essentially, he's just benign means benign. I mean, it's like benign means pretty much like unnoticeable. So I mean, far cry from the supposed murderer that he's supposed to be, but we'll move on from that. Anyways, he also says, Judge Duffin does, when he's weighing the different possibilities of harm and who could be harmed and what harm could come, and he's basically saying the state is not going to be incurring, the harm the state is going to incur is not anything compared to the harm that has occurred to Brendan. And he basically says every day that the petitioner stays in prison compounds the substantial harm that that he has suffered because of an unconstitutional conviction. So he's clearly stating that he feels that the original conviction was a complete farce, really. And to the point that he is saying that Brendan is the victim. And I think that's powerful. He's basically saying every day that Brendan spends in prison is just way more harmful, and it compounds every single day because of the substantial harm compounds every day because he has suffered at the hands of an unconstitutional conviction. So that's pretty powerful. He also goes on to mention the fact that the state really has nothing, and he's right. Besides the March 1st conviction, he says it straight up. He's like, with the exception of without the March 1st conviction, the state really doesn't have anything to retry him, and he's basically just laying it right out there, and he's saying, and this confession is not voluntary. Now, that's what the Seventh Circuit Court is going to be looking at, and we're gonna see which way they go on it. So that's going to be the next hurdle. Brendan will get out, though, it looks like, most likely here, but Mr. BS, pun intended, Brad Schimel, he is going to be filing an emergency motion with the Seventh Circuit Court tomorrow and stuff. He's going to be trying to stop it, but we'll see about how that goes. But you can tell Judge Duffin really, really thinks that Brendan has a very strong chance. And this is the one thing that really, really made me feel good. This is the one thing I saw in here that I thought was just totally outstanding. I'm going to show it to you right now. Thus, having been granted relief under both 28 U.S.C. D1 and D2, Dassey is arguably in a stronger position than the ordinary habeas petitioner. To ultimately prevail, Dassey need only persuade the Court of Appeals that one basis for the court's decision was correct. So essentially, he's only got one hurdle to get over because there's no other evidence that the state has on him anyway, basically, is what he's getting at. So, I mean, that just fills me with hope. I love that statement. I really like Magistrate Duffin. He's awesome. So, just thought I'd show you guys that. All right, so there we see where Magistrate Duffin basically says that as a habeas petitioner, Brendan is, you know, extraordinarily in a stronger position than most other habeas petitioners. That, you know, and he goes into saying that the reason why is because one of the main reasons why is because there is no evidence tying Brendan to this crime. The only thing that made any of these charges stick was the confession, and he has already deemed that ridiculous and involuntary. So he's basically stating that if the state doesn't win their appeal, which pretty much him and Brendan's defense team and, you know, many others believe is not likely to be successful, that Brendan's going to be out, because they may try to retry him, but that's not going to be right. That's really not going to be successful either, because there's no evidence left to tie him to it. All they ever had was the confession. So, anyways, we're going to move on to the last part here. The last part is basically just the final paragraph where Magistrate Duffin summing up, kind of in his last, you know, paragraph there. So, and then he signs his name. So we're going to go into that right now, so you can see that, and then I'll come back and speak for just a real short. It is therefore ordered that Dassey's motion for release, pursuant to federal RAP P23, is granted. The respondent shall release the respondent shall release the respondent upon the United States Probation Office notifying the court that it has approved the proposed residence and completed whatever additional investigation it deems necessary. The court will then issue a further order directing the respondent to be released by the petitioner. Dated in Milwaukee, Wisconsin, this 14th day of November 2016, William E. Duffin. All right, so in the end here, I just wanted to say that, you know, it's really, really awesome that Brendan, the prospect that Brendan may be getting out this week, I mean, that is just totally stellar. I mean, it'll be really cool that he will be out of prison. He will be able to, you know, speak for himself on it, you know, and he'll be able to say things to anybody. He won't be in prison where he's restricted from communicating, you know, only with people that can visit him. So he'll probably get introduced to Facebook and things like that, and he'll be able to be, you know, a big reason why people will suddenly flood back into the MAM chat rooms, and they'll want to start talking about this again, because him getting released is big, and it really is. I've been saying this for a while. Him getting released is a big deal. He gets out, he's like the standard, you know. He's the rally point where everybody's going to want to rally around him, and it's going to bring a lot of attention back to this whole thing, to Zellner's testing that's going to be going forward with Stephen here coming up. I mean, all of it. It's all going to be, I mean, I think we're going to see a big inrush of interest again, and I think that only serves to help. So I think that's awesome. And I'm really happy for Barb and Scott and everything, that they're, you know, going to be able to see Brendan, and they're going to be able to hug him, and they're going to be able to take really, really good places to eat, because I'm sure he wants to go have some really good meals. So, I mean, it's just really exciting. I really am, you know, just totally excited for him and his family, and I hope eventually he gets to go over and give Dolores a big hug too. I love Dolores. I think she's great, and so especially after seeing that picture posted the other day on Facebook of, you know, it was an older picture back when Dolores was still able to go visit Brendan, you know, while she could still do the stairs. But I just love seeing it, and I love seeing Dolores. I think she's great, and I'm just happy for Barb and obviously Brendan. So just going to end it on that note and say, please subscribe if you haven't already, and we'll see you guys next time.